All right, good morning, everyone. Apologize for the delay in setting up our technology. Court calls cause number 20-00130, J&L versus L&L. Little housekeeping matters before we get going. We're going to stop promptly today at 12. We're going to break for lunch 12 to 1:30, so you can make your lunch plans around there. We'll begin promptly at 1:30 as well. Before we get going, let's be reminded that let's work well with my court reporter here. Make sure that since we're going to have live testimony today, talk to your witnesses beforehand. Make sure that we're not talking over one another, so my court reporter can take down an accurate record today. I believe that the only issue before the court today is the motion to compel arbitration. Is that correct?
That's correct, Your Honor. Yes, Your Honor, that is correct.
And how many witnesses do we anticipate today, Mr. Sanders?
My intention is to call 2 witnesses who I would expect would take up the balance of the day, and that would be Mr. Thayer and Nancy Boyd. It's possible we can call additional witnesses, but at this point, I feel reasonably confident to say that those 2 witnesses will take up the day.
Mr. Lasser, what do you anticipate?
Your Honor, it's our motion, and so we will be going first. In all fairness, we filed a reply yesterday to the response, and I'd like to.
And I've reviewed your original motion. I've reviewed Mr. Sanders' response, and I've reviewed your reply to the response. And so it was my understanding, though, that there was almost a concession or a stipulation that the first element had been that there was an arbitration provision in the contract. And the question for the court today is going to be, was that a valid, and is there any defenses to that? So I just assumed that he was stipulating to such, and he was going to put on his evidence, but go ahead.
Your Honor, I think that is, and I'll kind of reserve till we get into the full argument, but as we open the motion, that at least our understanding of the law, we set it forth in our reply, is there's 2 initial inquiries. Number 1, is there an agreement to arbitrate? And I don't think there's a dispute over that issue. The second is whether or not the claims asserted are within the scope of the arbitration agreement. That's a question of law, frankly, by the court. The issue in terms of whether or not the court actually moves forward and conducts an evidentiary hearing is whether or not the party resisting arbitration has come forth and put forth some evidence in the form, solely in the form of the declaration of Nancy Boyd, that would raise the issue of procedural unconscionability. And it's not procedural unconscionability as it relates to the contract as a whole. As we've set forth in our reply, and it's set forth by the Supreme Court in the In Re First Merit case that we delivered a copy to the court. But it's whether or not it is procedurally unconscionable related to the inclusion of and the circumstances surrounding the inclusion of the arbitration agreement within the contract. Whether the contract as a whole is unconscionable, whether the contract as a whole was fraudulently induced is frankly a question for the arbitrator for compelling arbitration. That's part of the issue of arbitration. But the first kind of threshold issue, and I don't think that the plaintiffs have gotten there with the declaration of Ms. Boyd, is whether or not they've raised enough of a fact issue to require evidentiary hearing the issue of procedural unconscionability. And I'll argue that as part of my opening comments, explain to the court why and how we frankly don't need to have any kind of evidentiary hearing because they've not tipped the threshold and flipped the burden back on us.
Okay. Mr. Sanders, would you like to reply?
Your Honor, I cited cases in our response. For example, Dallas Cardiology Associates versus Malik. Burden is on us to show the arbitration agreement. Some grounds exist in law or equity, the revocation of contract. Such grounds could include fraud, waiver, unconscionability, or that the dispute was not within the scope of the arbitration, within the scope of the agreement. We admit we have the burden. If we can't meet our burden, then we're going to arbitration. So in terms of,
And opening statement from opposing counsel, I think the court's well aware of both sides' positions. And they agreed to have an evidentiary hearing on this matter. We're here, the witnesses are here. Instead of having a long argument from Mr. Leister, let's save it for the close and let's get on with it and start calling witnesses, which we would start with Lance Thayer.
Well, I think what Mr. Leister's argument is that you have not met your burden for an evidentiary hearing.
And I believe we have, Your Honor. The problem that we have is there aren't really any cases addressing a fiduciary, someone with an existing fiduciary duty, getting their principal, to sign a contract with an arbitration clause and not raising that with the counterparty. And that's because it's what the defendants did here is so brazen. I don't think anybody's gone and tried to do it. The fact of the matter is, when you have a fiduciary, the fiduciary has a duty of disclosure. And if they don't meet that, they don't fulfill that duty, then you have unconscionability. I looked certainly in Texas and could not find a case on that. The closest I found was a case out of North Carolina where the North Carolina Supreme Court said that a doctor had an existing fiduciary duty to a patient, and that when the doctor had that patient sign a bunch of forms that included an arbitration clause, the doctor breached his fiduciary duty by not pointing out the arbitration clause and explaining it to the patient. You know, are we going to find another case where the chief restructuring officer of a company buys the company's assets and sticks an arbitration clause in there and doesn't say, hey, you should look at this arbitration clause and what does it mean? No, we're not going to find that case. Again, I don't think anybody's ever been as brazen to do that. So admittedly, this case probably, if we can't resolve it at some point before then, this case likely goes to the Supreme Court, because the Supreme Court's going to have to decide, is there a set of facts in a commercial context short of an imminent threat of physical violence that would get anyone to a procedural unconscionability finding? I think this case, as the facts we've laid out in Mrs. Boyd's affidavit and also that we'll develop here, get us there. I mean, it's not just the breach of fiduciary duty. As the case law says, it's the entire atmosphere of the situation. So again, I don't see any benefit in bringing everybody up here like we planned to do already, and then just saying, forget it. So I'd ask that we be allowed to proceed with putting on our case to prove our burden.
Thank you, Mr. Sanders. So, Mr. Leister, you're saying that in your review of Ms. Boyd's affidavit that you don't believe that she has sufficiently controverted the alleged facts?
Well, it's not controverted the alleged facts. The issue deals with it. There has to be some evidence of procedural unconscionability regarding the inclusion of the arbitration clause. And when you look at Ms. Boyd's declaration, it has one paragraph whatsoever that touches on the issue of the arbitration clause, and it's paragraph 15. And there it says, Ms. Boyd declares in her declaration, no mention, much less an explanation of the arbitration clause in the contract for sale was made during the April 20 of 2020, that meeting. And here's why and how that doesn't tip the scales. I mean, all of the other issues, whatever they are, that are attempted to be raised in her declaration, say nothing whatsoever of the inclusion of the arbitration clause. Either it was falsely explained, or we were told it wasn't in there, or things of that nature. And the cases that I cite, in particular in our reply, I would direct the court to the Delfingen Delfingen U.S. versus the Valenzuela case provided to the court. That was a case wherein a employee went to work for somebody, and they didn't speak any English. And the agreement that they were presented required arbitration of disputes between employee and employer. The agreement that was presented was in English. The fact that the person who signed the arbitration agreement was illiterate was not enough. The fact that they didn't even speak the same language was not enough. And however, they ended up not being able to go to arbitration, not because of that, but because of the fact that the agreement had been misrepresented. The agreement had been misrepresented to not contain any such clause. There's nothing in Ms. Boyd's affidavit that even touches on that issue. And in fact, she acknowledges it was there and acknowledges that there was no mention of it or no explanation of it. She simply has not met the burden to even require evidence. Yes, we came here for a hearing. It's on my motion to compel arbitration. I didn't agree that evidence would be presented. They still have to jump through the procedural hoops to even get us to the point where evidence is needed. And because of the fact that we didn't know until Ms. Boyd filed her declaration on Friday of this last week what she was going to say, and now we do, and what she has said is simply not enough to raise a fact issue regarding procedural unconscionability as to the inclusion of the arbitration provision in the agreement. That's what's required. That never happened. As a result, the inquiry stops at, was there an agreement to arbitrate, which we certainly agreed to, and then the court needs to decide as a matter of law whether or not the claims asserted fall within the broad arbitration agreement that's part of the contract for sale that gave rise to this dispute in the first place. I want to address one other issue, which was the fiduciary duty issue that was raised by Mr. Saunders. There is a case, and we've cited it, and we delivered a court copy of it, wherein there was a arbitration agreement in a engagement agreement between a lawyer and a client, and which is as close as we can find to a fiduciary duty scenario. But in that particular agreement that the court found, the Supreme Court actually found, to not be unconscionable. The lawyer had required that if the client had a dispute with the lawyer, it had to go arbitrate. However, if the lawyer had a dispute with the client regarding the payment of fees, in other words, two different standards. If the client has a dispute with the lawyer, that's required to go to arbitration. However, if the lawyer has a dispute with the client regarding payment of fees, that's carved out and can go to litigation. Texas Supreme Court found and determined that was not sufficient enough to be unconscionable. So it's as close as we can get to the fiduciary duty issue that Mr. Sanders raised. Texas is broadly in favor of enforcing arbitration provisions, and has been so for years, and we set forth all of the law. We set forth all of the law in our reply. And the bottom line is, they simply didn't get there. And so the counter to Mr. Saunders' argument is, we've got everybody here, but you still need to follow the law. And the law is, they didn't get there. They did not get there in terms of raising the issue of procedural unconscionability. And so we're done. There is a valid agreement to arbitrate, and there is their claims are within the scope of the arbitration agreement as we set forth in our reply. I've got extra copies of the case. And Your Honor, in our reply brief, obviously you're presumed to have read what you signed, you're presumed to be bound by what you signed. We cite all of that law. That's the scenario we have, and there's been nothing to indicate anything to the contrary. There was a misrepresentation. In fact, Ms. Boyd's affidavit or declaration goes the other way and says it wasn't mentioned, it wasn't explained. Been no misrepresentation. They're bound by the agreement that clearly contained an arbitration clause, and we're not. So we think the appropriate thing to do would be to hear argument, if you will, on the whether or not the claims fall within the scope of the broad arbitration agreement. Hear no testimony. The court decide whether or not the claims asserted fall within the scope as a matter of law. You know, I've got extra copies of the case if the court would like.
I'll get those at the end of the hearing. Mr. Sanders.
Your Honor, I saw the cases about here in Texas that an attorney can put an arbitration clause in their engagement agreement, and that certainly is the law. There's not any cases that address what would the court do if it wasn't something that was signed on the front end when the fiduciary relationship is being formed. Instead, it's after the fact, after the fiduciary duty had been established. And I'd submit that if the courts were presented with a situation where original contract doesn't contain an arbitration clause, and then on the eve of trial, the lawyer tells the client, hey, you need to sign this new agreement right now, or I'm not going to try this case. And doesn't say to the client, there's an arbitration clause in here, what that arbitration clause means. Gets the client to just sign it, and then later on says, oh, well, arbitration clause. I can't imagine the Texas Supreme Court would sanction that conduct and say that that was not procedural unconscionability. That is the closest analogy I can come to for, as to Texas law, to a case on point. Now, it's interesting that he brings up the Delphinian case, which we also cited. And the 2 points I'd make about that case is, I don't believe that there was an affirmative misrepresentation as to there's not an arbitration clause in here. It was a misrepresentation as to what was in the contract generally. There was no question that the employee was relying upon the employer because she didn't speak English. Similarly, the J&L Utility Service Company was relying upon its fiduciaries, its CFO, Kelly Mills, its CRO, Lance Thayer, in signing this contract. It's also interesting that they cite Delphinian, because Delphinian makes this point. The employer cites the rule that absent a duty to disclose, such as in a confidential or fiduciary relationship, an agreement is not unconscionable or fraudulent merely because one party was not informed as to the arbitration process provisions. But in this case, Delphinian knew that Valenzuela did not understand English, and it required her to attend an orientation session during which the company representative told her she was going to translate the important parts of the document. I mean, the court there in Delphinian recognizes the rule that we're trying to invoke. And just saying, well, you can't cite me to a Texas case where somebody did this horribly bad thing, therefore you don't even get to put on evidence, is, I think, just doesn't make any sense. The last thing I do is I will cite to King versus Bryant, and I've got a copy of that case also. But the long and the short of that case is the North Carolina Supreme Court said doctor had an existing fiduciary duty, breached that duty by not pointing out to the patient, there's an arbitration clause here and here, and what does it mean? That was enough in that situation for the North Carolina court to say, no, we're not going to enforce that arbitration clause. We have that plus a lot more in this case, which we can develop once we start putting on evidence as to what happened here.
Where in the contract is the arbitration? What page is the arbitration provision on?
It's in the section called dispute resolution, Your Honor.
I understand that. What page is that on?
Hang on a second, let me find it for you.
5, Your Honor, paragraph 18.
On page 5 of the contract?
Yes, sir.
Ms. Boyd's affidavit says in paragraph 14 that she stated she had no opportunity to read the agreement beyond the second page. If that were true, would that mean that she would not have the opportunity to know of the arbitration agreement, much less that's included?
No, Your Honor. And when you look at the language of the Delfingen case.
Right, but I guess what am I missing here? If this were true, if what Ms. Boyd says is true, then she never got to page 5.
I understand that, but she signed it, Judge.
Understand.
She was not prevented from looking at it. She doesn't say she was prevented, precluded, or she was told that it just had to do with the sale, didn't have anything to do with anything else, like in the Delfingen case where they just said, hey, it has to do with the attendance policy. And in that case, there was a situation where the employee didn't speak English, didn't have an ability, or read English, didn't have an ability to read it herself. But the court in that case, even there, says you're presumed to have read and understood and know the meaning of what you signed. If that were the case, Judge, then people would undo every contract by saying, hey, I just signed it. I'm not bound by it.
No, I understand, but that's not the question here. The question here is was she aware of the arbitration provision in the contract at all?
The law
and
says.
for me, the test is there some kind of controverting evidence? And here I've got this affidavit that seems to controvert your position, that she should be aware of what she signed, that there's a presumption that she understands that what she signs and the provisions therein. I'm looking strictly for whether or not there's anything that controverts the material facts in this before the court for me to decide whether or not I should have an evidentiary hearing on the motion to compel arbitration. So my question is if this is true, would that not controvert the material facts to the point that the court should at least entertain evidentiary hearing to allow them to see if they can meet their burden?
I don't think it does, Your Honor. Let me explain why. She says she didn't, and I have to get the exact wording of her declaration as it relates to that.
Well, and I'll tell you, Mr. Leister, I took comfort in your reply where you agreed that it would be helpful to the court because I would be shocked. Both of you gentlemen said I would be shocked after the evidentiary hearing. You said I'd be shocked about what happened that day. You said I'd be shocked by what did not happen that day. So I read this and I thought, great, they finally agree on something.
Piqued your interest, huh?
It did. It did. So I thought, well, that's definitely got to put the court in a better position to hear the evidence. And if I'm going to be clearly shocked by one side or the other, it should make my job easier.
Yeah, Your Honor, and I mean her. Let me just get the declaration in front of me again. It's in paragraph 14. Pardon me. It's actually no, it's not. It is. Bear with me.
That's fine. And I understand that you're
Yeah,
urging that she's incredible at this point.
paragraph 15 says we had, pardon me, no mention, much less an explanation of the arbitration clause in the contract for sale was made during the April 2020 meeting. That statement, in connection with the black letter law, which is you're presumed to have read, understand, and be bound by what you signed. I mean, if there's no mention of it, how can there be any kind of a misrepresentation that led to the execution of the agreement that contains the arbitration clause? And again, it has to be specific to the inclusion of the arbitration clause. It's not the contract as a whole. And what the plaintiffs are attempting to do is get you to look at the entire contract as a whole, and they didn't say this, and they didn't say that. That's way too broad, and frankly, it's irrelevant to the court's inquiry here today. The court's inquiry here today has to do with whether or not they tipped the scales that entitled them to an evidentiary hearing. And it's our motion, so we go first, but whether they've tipped the scales to even allow an evidentiary hearing on the issue of procedural unconscionability regarding the inclusion of the arbitration clause. That's it. And the fact that there's nothing in there about any kind of a misrepresentation concerning the inclusion of an arbitration clause or the lack thereof, or a misrepresentation that says, hey, don't worry. I mean, there's nothing in there that touches on the arbitration clause other than Ms. Boyd's affirmative declaration that it wasn't discussed. It wasn't read. It wasn't explained. And then she signs the contract. If the law were as what Mr. Sanders would have us believe, someone could get out of an arbitration provision by simply saying, hey, I didn't read it. It wasn't explained to me. I didn't see it. You signed it, though. You're bound by it. And there's nothing in there whatsoever that talks about how it was misrepresented to be this versus that, or it was misrepresented to not have it in there, or it's misrepresented to be something other than what it was, and Ms. Boyd be incapable of reading it herself, such as in the Valenzuela case. That's not there. Because that's not there, they've not tipped the burden to even get to where they get to put on evidence of procedural unconscionability regarding the inclusion of the arbitration clause. That's what they have to show, and they just didn't do it. And if they didn't do it, as a matter of law, we can argue about whether or not it's within the scope of the claims, and I'm prepared to do that, or whether it's not. But they don't get to the evidentiary presentation unless they've tipped that scale, and they failed to do so by her declaration.
All right, I'm gonna tend to disagree with you based on her declaration, so I'm gonna allow the evidentiary hearing today.
Your Honor, just for the sake of preserving the record, I'd like to object to the evidentiary portion just throughout, if that's all right, just so that I preserve that error. I know what the court's ruling is going to be, but I don't want to waive that.
Yes, sir.
Okay, I have that objection.
Granted.
Thank you.
All right, call Lance Thayer.
Well, I think there's still so is there not an agreement as to, between the parties as to who's going to put on the evidence?
Your Honor.
I'm assuming.
Your Honor, it's our motion.
I understand.
Our motion to compel arbitration, and we go first because it's our motion. So Ms. Morris is going to call.
Your Honor, may I reply?
Go ahead.
The key is, it's not whose motion it is, it's who has the burden at an evidentiary hearing. We have the burden. We have to show, if we stop right now without an evidentiary hearing, then yeah, we've got to put on evidence that says we don't have to go to arbitration. So we just, the cases they cite, it's clear. Once they make their initial showing, then the burden is on the party trying to resist arbitration. So let's.
And do you stipulate to the initial showing?
Yes, they did. They got it. It's now on us to show either unconscionability, as shown in the stated in the Dallas cardiology case, either unconscionability or that there is something that does not fall within the scope of the arbitration clause.
And Mr. Leister, you don't want to accept that stipulation?
I'm fine with the stipulation, Your Honor. I mean, the issue though, it's our motion to compel arbitration. I mean, we're still going to ultimately have to prevail on our motion to compel arbitration. So
I understand that.
it's our motion. We ought to go first.
It's in essence, we're putting on an affirmative defense. So that's,
I think it's going to be better use of the court's time. If you're accepting the stipulation, I think it's going to be better use of the court's time for them to put on their evidence. If they don't meet the burden, then we're done.
Well, I mean, I think we're going to end up having multiple witnesses, Your Honor. So it's.
Y'all already told me that.
Yeah, we're going to end up putting on a fair amount of witnesses ourselves, in addition, depending on what transpires. So, I think in essence, we're going to end up calling two of the same witnesses, obviously, Mr. Thayer and Ms. Boyd. And so,
Let me see if I can make it easy. Do you accept the stipulation or do you not?
stipulation being, just want to be sure I'm
That
absolutely accurate.
you have met the initial showing of showing that you are entitled to motion to compel by the valid arbitration agreement.
Yes.
All right. Then Mr. Sanders is going to go first.
call Lance Thayer.
Mr. Thayer?
Oh, I'm sorry, Your Honor, we'd like to invoke the rule.
All right. If counsel, if you have everyone stand up that's going to testify today and come forward, please.
Yes, you. We're going to call Nancy Boyd in addition to Mr. Thayer.
Ms. Boyd, watch your step.
And Your Honor, we may need to call Mr. McConaughey and I believe this is Ms. Swope here. They'd both be witnesses, so we'd like to invoke the rule on them.
Your Honor, and as it relates to Mr. McConaughey, on the 13th of this month, the plaintiffs amended their pleadings and named a new party company by the name of J&L Line Services and served Mr. McConaughey as its registered agent, so he would be here as the representative or corporate representative of that entity.
If that is the case, then yes, he would get to stay in the courtroom.
Okay. So these are the only three that are going to testify today?
Again, I think. Okay, yeah, I think Ms. Swope may be one of the witnesses who are going to be called. I certainly may need to call her, so.
Is she here?
Yes.
You, Ms. Swope? All right, Ms. Swope, if you'll come forward. I'm going to go ahead and swear you at this time. If each one of you will raise your right hands, each of you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God. Ms. Boyd, Ms. Swope, Mr. Thayer. Okay. And Mr. McConaughey? All right, you may put your hands down.
Your Honor, since we have two other plaintiffs here, Ronnie Boyd and Sarah Boyd, we may end up calling them to get them sworn in as well. They serve.
Yes, yeah, that's
If they
that's
say
what I
they
wanted.
can
Y'all
call
tell me who you're going to call. And it's Ronnie Boyd and Sarah Gary, is that correct? Each one of you raise your right hands. Do each of you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Ms. Gary? Mr. Boyd? All right. All right, at this time, you are each being placed under the rule of sequestration. That means that you're going to be ordered out of the courtroom. You're not to discuss this case with anyone except the attorneys. Speak to them or their staff. Do not speak to each other about this case or anyone else related or unrelated to the case unless it's counsel. Your failure to follow that order could result in the court finding you in contempt of court. The court could also strike your testimony in this hearing today. Each one of you understand that? All right, so at this time, I'm going to order all of you, with the exception of Mr. McConaughey, to exit the courtroom and abide by the court's order.
I'm sorry, Your Honor, Mr. Boyd and Ms. Gary are individually plaintiffs in this lawsuit.
Then you may remain.
Thank you, Your Honor.
Your Honor, just as a housekeeping measure, I may have two other witnesses that are not here now that will be here after lunch.
Okay. All right. And Ms. Boyd, you can have a seat.
Sit back
Now,
down.
bailiff, if you'll assist her, make sure she does too. And if they're not using the electronic, you may just move that out of the way so if she walks through there. Yes, Mr. Leister.
Your Honor, you have the day set aside, I think, for this. Is that
I do.
correct? Okay,
Yes.
so from a time allocation standpoint, we just keep going until we get it done, hopefully today. Is that fair?
We're going to go till 5 o'clock.
Fair enough.
So I'll keep track of how long each one of you are going. I'll try to make sure that that's allocated fairly.
Thank you, Your Honor.
All right, Mr. Sanders, you've called Mr. Thayer?
Yes, Your
All
Honor.
right, Mr. Thayer, you've been placed under oath. If you'll come have a seat with us. And just a reminder that make sure you speak up loudly and clearly, Mr. Thayer, so my court reporter can take down everything that you're saying. And you were in the courtroom earlier and heard the emergency vehicle go by. It's very kind of deafening, hard to hear. So if that happens during your testimony, just stop your testimony, let that sound pass, and we'll resume. Make sure that you allow the attorneys to fully ask their questions before you respond. And the attorneys are going to extend you the same courtesy. They're going to allow you to respond before they ask these questions. Mr. Sanders?
Mr. Thayer, will you please state your full name for the record?
Lance Thayer,
Do you have a middle name?
Lance Johnson Thayer.
Thank you. Your Honor, to save a little bit of time, we have our exhibits pre-marked. It's possible we won't use all of them, but I think it'll save time. I've got a copy for the court reporter, copy for the witness stand, copy for opposing counsel. Well, actually, most of the exhibits were previously provided to opposing counsel, and then a copy for the court. If I may approach.
Have you spoken with Mr. Leister about that to see if there's an agreement on admissibility of those?
We've not had a chance to.
We'll go ahead and let's do that at this time.
Well, I'm not trying to offer all of them in mass. I'm just trying to save time going back and forth between the witness stand and the court reporter and the court.
How many exhibits do we have?
There's a lot more in here than we probably will actually use. What I did was just save time on our end was a lot of our exhibits that we were going to use at the injunction hearing. We just kept the numbering and added on to them. So we're probably going to skip a fair number, but we'll probably end up using those exhibits on Thursday. So I'm just trying to save some confusion in terms of what is what exhibit number. I'm not asking for a stipulation on admissibility. I just want to, again, save time going back and forth between the court reporter and the witness in the court, since we only have the day.
All right, just leave them up here. I don't want to see them until they've been offered, so.
All right, that's fine.
I think that's only fair.
Okay. This is the errors that we didn't have before. This is the one we had before the August 13th.
You have the full set.
No, it's the set that was August 13th. We just picked up with.
But since I don't have witness with me from temporary injunction.
Just, okay.
Full set.
That I'll just have to take the court reporter's copy and give it to the witness. This is the last one. Actually, Your Honor, if I may, maybe we have one set for the, I'll put one set right here between you and the witness, and one set. Mr. Thayer, where are you presently employed?
I own my own businesses.
I'm sorry, you own
I
what?
own my own businesses, so I
You
guess I'm
own-
self-employed.
You're self-employed. And is one of those business a utility service company here in Van Zandt County?
Yes.
Now, the location we're talking about where that business is, sorry, is conducted is at 1589, sorry, I'm going to start over. It's at 15891 Highway 80 in Edgewood, Texas, right?
Yes.
And before you ever had any connection with that business, my client, J&L Utility Service Company, was running a utility service business at that location on Highway 80.
To the best of my knowledge, yes.
Can you take a look in the exhibits there? At the first one, Exhibit 1.
I'm going to need my reading glasses.
Can council assist Mr. Thayer with his reading glasses?
If I get mine up, I won't be able to read.
Likewise. Likewise.
Age. Can you repeat which, I'm sorry.
Do you have Exhibit 1 in front of you?
I do.
And does that appear to be a copy of the unanimous written consent of the Board of Directors of J&L Utility Service Company dated March 10th, 2020?
Yes.
And you were present when Exhibit 1 was executed, right?
Yes.
Offer plaintiff's Exhibit 1.
Any objection?
No objection, Your Honor.
Our plaintiff's exhibit 1 is admitted in evidence.
Now, in Exhibit 1, Board of Directors of J&L Utility Service Company appoint you to the office of Chief Restructuring Officer, correct?
Yes.
And then there is a Kelly Mills who is appointed as Chief Financial Officer, right?
Correct.
Kelly Mills is a certified public accountant, is that right?
Yes.
And had you ever worked with Ms. Mills before her being appointed as Chief Financial Officer of J&L Utility Service Company?
Yes.
And are you still working with Ms. Mills on any projects this time?
No.
Was her involvement with J&L Utility Service Company the last time you had you worked with Ms. Mills on anything?
Yes.
Now, starting on March 10th, 2020, you and Ms. Mills had complete financial control of J&L Utility Service Company, right?
Ms. Mills and I were appointed to handle the banking arrangements of J&L Utility Service Company.
And from that point forward, the two of you were the only ones who could sign checks on behalf of J&L Utility Service Company, right?
That's correct.
And you knew that the Board of Directors of J&L Utility Service Company were relying on you and Ms. Mills to handle the banking arrangements, right?
As a stipulation from the First National Bank of Gilmer on staving off foreclosure, they asked that the Boyds be removed from having any ability to write checks or take monies from the company, and that was their position.
Objection, non-responsive, and hearsay.
Sustained as the hearsay.
You had been out to visit the J&L location on Highway 80 before March 10th, 2020, right?
Yes,
And you had at that time said that J&L Utility Service Company was the kind of business that you would be interested in buying, right?
I don't recall saying that.
Take a look at Plaintiff's Exhibit 2. Is Plaintiff's Exhibit 2 a copy of a letter of intent signed by you personally and Nancy Boyd as president of J&L Utilities?
Yes,
And that is your signature on page 3?
yes.
Offer Plaintiff's Exhibit 2.
Any objection, Mr. Leister?
No objection, Your Honor.
Exhibit 2 is admitted in evidence.
Now, at the top of Exhibit 2, there is a handwritten notation of the date of March 20th, March 27th, 2020. You see that?
I do, yes.
And it looks like those your initials and Mrs. Boyd's initials there.
Yes,
And so is that notation correct, that this letter of intent was executed on March 27th of 2020?
yes.
Nowhere in this letter of intent is there any price stated for the business, right?
I'd like to take a moment to read it. Correct.
After, or starting on March 10th, 2020, the Boyds continued to be the owners of the corporation, J&L Utility Service Company, right?
To the best of my knowledge.
So although you and Ms. Mills were the only ones who could sign checks, the ownership of the company or the business had not been turned over to you at that point, on March 10th, 2020.
I'm not sure, can you repeat the question? I'm not sure I understand what you're asking.
On March 10th, 2020, you didn't then, right then and there, obtain an ownership interest in J&L Utility Service Company, right?
No.
And on March 10th, 2020, you didn't then and there obtain an ownership interest in the assets of J&L Utility Service Company, right?
No.
Is what I said correct, that you did not obtain that interest?
On March 10th of 2020, I did not purchase assets of J&L Utility Service Company.
Can you take a look at Plaintiff's Exhibit number 3, please? Is Plaintiff's Exhibit 3 a text that you sent to Mrs. Boyd, Kelly Mills, and Sarah Boyd Gary?
Yes.
Offer plaintiff's exhibit 3.
Any objection?
No, Your Honor.
Plaintiff's exhibit 3 is admitted in evidence.
In this text message, you state, I spoke with Danny at the bank multiple times this week. Is that right? Is that what you said there? Do I correctly state what the text says?
Yes.
Okay. And Danny, that's referring to Danny Weems,
Yes.
who's the president of Wood County National Bank, a branch of the First National Bank of Gilmer. Is that right?
I believe at that time, yes.
And we can see from the date at the bottom of this Exhibit 3, this was something you sent before the April 20th meeting where the contract for sale was executed, correct?
Correct.
And you state in this text, make sure I correctly quote this, he indicated he will pursue legal action for loan fraud against all individuals that signed on the bank's loans, $478,000. I spoke with him at length about this claim, and it's my belief that the bank has a good case against the owners of J&L. Did I read that correctly?
This is what Mr. Weems told me.
And you're passing this information on to the two of the owners of J&L Utility Service Company, right?
This is what I put out to the group.
I'm sorry?
This is what I put out to the group.
Take a look at Exhibit 4, please. Exhibit 4, is that a copy of the contract for sale that has been the point of discussion throughout this lawsuit?
Yes.
Offer plaintiff's Exhibit 4.
Any objection?
No objection, Your Honor.
Plaintiff's exhibit 4, contract for sale is admitted in evidence.
The contract for sale was in fact executed on April 20th, 2020, right?
Yes.
It was executed at a branch of the Wood County National Bank in Mineola, is that right?
Yes.
There were a total of 6 people at this meeting, correct?
Yes.
You were there, right?
Correct.
Kelly Mills was there.
Correct.
Richard McConaughey was there.
Correct.
Sarah Boyd Gary was there.
Correct.
Ronnie Boyd was there.
Correct.
And Nancy Boyd was there.
Correct.
Now, Mr. McConaughey, am I saying his name correctly? Is it McConaughey or McConaughey?
Maybe it's McConaughey.
McConaughey. Just wanted to make sure I was saying it right. Mr. McConaughey, he's an attorney, isn't he?
Correct.
Is he also your brother?
Yes.
He is primarily a DWI defense attorney, isn't he?
He is a criminal defense attorney, correct?
Criminal defense. Mr. McConaughey is the one who drafted the contract for sale, Exhibit 4, right?
Yes.
Before the April 20th meeting, you let the Boyds know that you were going to have another advisor at the meeting with you in addition to Ms. Mills, right?
To the best of my recollection, on 3 occasions, I let the Boyds know that I was going to have an advisor along with my legal counsel, Mr. McConaughey, be present.
I'm asking about before the meeting.
Yes.
Before the meeting, you didn't tell the Boyds that Richard McConaughey was your attorney, did you?
I'm not sure that I mentioned Mr. McConaughey's name.
So it's your testimony that you said there would be an attorney present.
I'm not sure of the date. We had 2 phone calls with Miss Boyd ahead of that meeting, and I let her know who would be present, along with asking her if she'd have counsel present as well.
And you mentioned Richard McConaughey would be present.
And again, I'm not sure that I mentioned that name.
But at the beginning of the April 20th meeting, you introduced Mr. McConaughey as an advisor, right?
I'm sorry, can you repeat that again?
At the beginning of the April 20th, 2020 meeting, you introduced Mr. McConaughey as an advisor, right?
Prior to our meeting that day on the 20th, we had introductions before the meeting started, yes.
At no point during the April 20th, 2020 meeting did you mention that Mr. McConaughey is an attorney, right?
Again, we had introductions before the meeting started.
Objection, non-responsive.
Sustained. Can you answer the question?
Can you repeat the question, please?
At no point, Ms. Broadman, at no point on April 20th, 2020, while you're there at the branch of the bank in Mineola, meeting with the Boyds, did you mention that Richard McConaughey is an attorney?
Mr. Saunders, I don't know if I mentioned he was an attorney or Mr. McConaughey mentioned he was an attorney or in our introductions at the meeting. I don't recall if I said that or Mr. McConaughey said that.
Well, at a previous hearing on this case, before we got started, your counsel provided a transcript of a recording of part of the April 20th, 2020 meeting. You aware of that?
I'm not sure I'm aware of that.
Well, were you aware that one of the 3 of you, Ms. Mills, and Mr. McConaughey, were recording that meeting?
Yes.
And are you saying you've never looked at the transcript of that meeting?
I have looked at the transcript of that meeting, yes.
You have. And nowhere in there is there any mention of Mr. McConaughey being an attorney, right?
Again, we had introductions to that meeting and I began the recording, and so I don't recall if on that transcript or not, if there's an indication he's an attorney or not.
So your answer is you don't remember whether the transcript says that or not.
I don't recall.
Now, Exhibit 4, the contract for sale, is not, you individually, Lance J. Thayer, are not a party to this contract, correct?
I'm signing on behalf of L&L Line Services.
Right. The two parties to the contract are L&L Line Services, LLC, and J&L Utility Service Company, right?
Correct.
L&L Line Services, LLC, that is an entity that you formed, right?
Yes.
The L&L stands for Lance and Laney, right?
Correct.
And Laney's your wife.
Correct.
You formed L&L Line Services, LLC, the same day as this contract was signed, right?
To the best of my knowledge, I believe so.
The check for $50,000 that was delivered during the April 20th meeting, that wasn't from an L&L Line Services LLC bank account, right?
I don't recall that.
Well, on April 20th, 2020, that day you had not opened any bank accounts for L&L Line Services.
No, I don't believe so.
The check actually came out of a company called Thayer Wealth Management, right?
I'd have to see the check, but I'm not going to dispute that.
On April 20th, again, the meeting we're talking about in Mineola, you agree with me that that meeting lasted less than an hour?
No, I don't agree with you to that.
How long do you think the meeting took? Or how long did it last?
Approximately 2.5 hours.
At no point in the April 20th, 2020 meeting did you mention anything about an arbitration clause in the contract for sale, right?
I don't recall mentioning anything about an arbitration clause.
During that meeting, strike that. Mr. McConaughey was at the meeting at your request, right?
Yes.
And he was representing you and or your company, L&L Line Services, right?
Yes.
And Ms. Mills was there also at your request, right? As far as you're concerned, L&L Line Services LLC I'm sorry, is there?
Do you hear feedback?
A little bit.
Yes, sir.
Yeah, well, I'm more worried about you.
I do.
You do. Go ahead, Mr. Singh.
As far as you're concerned, L&L Line Services LLC became the legal owner of the assets of J&L Utility Service Company on April 20th, 2020, right?
Yes.
So before the contract for sale was executed, there were employees who worked at the utility service business being conducted there on Highway 80 in Edgewood, right?
Yes.
So the next day, April 21st, 2020, did those same employees become employees of L&L Line Services LLC?
I would assume so.
Well, as we sit here today, does L&L Line Services LLC have any employees?
I'm not following your question.
I don't object to this line of questioning is related to the issue of procedural unconscionability regarding the inclusion of the arbitration clause.
We also have the issue of whether or not the later purchase of the notes is something that falls under the arbitration clause. And if the allegation is it was done by L&L Line Services, all right, well, we've got to explore the relationship there between L&L Line Services and the contracts that don't have any arbitration clauses in them, being the notes and the security agreements and the deeds of trust, and the contract that was signed that has the arbitration clause in it.
And Your Honor, whether the employees were employed by L&L has nothing to do with the issue we're here to talk about today.
I'm going to sustain the objection, and I recall him saying that he assumes that they were his employees on the next day.
Step forward to June of 2020. And it's your contention that L&L Line Services LLC purchased the secured lien position of Wood County National Bank, a branch of First National Bank of Gilmer, right?
I'd need to see those documents on June. Sure about that date.
You're not sure about June as to being the purchase?
Again, I just have to see the documents.
All right, let me back up. Just generally, forget about the date. It's your contention that J&L Utilities, it's your contention that L&L Line Services LLC purchased the notes, deeds of trust, security instruments held by Wood County National Bank, right?
Yes.
Did L&L Line Services LLC actually pay the bank for that purchase?
That I don't recall.
You don't remember if L&L Line Services LLC was the remitter of the funds to the
I would assume so, but I'd have to look at that.
before signing any kind of contract to purchase the secured lien position, you had some kind of discussion with someone at the bank about making that purchase, right?
Which bank?
Wood County National Bank.
I don't believe it Wood County National Bank, no.
Wood County National Bank, a branch of the First National Bank of Gilmer, has changed names since, say, June of this year, right?
Correct.
Do you recall at the time it was known as Wood County National Bank, a branch of the First National Bank of Gilmer?
Mr. Saunders, you're asking me if I spoke with anyone at Wood County National Bank related to the purchase of the notes. My answer is no.
So you just walked in one day and the documents for the purchase of this note were just there and ready to be signed?
Mr. Saunders, I'm not disputing that I bought the notes, but I talked to someone at, I'll offer that at First National Bank of Gilmer, not Wood County National Bank.
You spoke with somebody at the First National Bank of Gilmer?
Right.
All right. And that would have been Danny Weems, right?
That's correct.
Did Danny Weems demand that you purchase the bank's, the First National Bank of Gilmer's secured lien position? Well, you've stated in some documents filed in this lawsuit that you went to purchase the notes because Mr. Weems said he was going to begin foreclosure proceedings, right?
I approached Mr. Weems on purchasing the notes to secure my interest and position in the real estate and the wheeled vehicles at the property.
Objection, non-responsive.
Sustained.
Repeat the question, please.
You understand that your lawyers have submitted documents in this case on your behalf stating that the purchase of the bank's secured lien position was the result of the bank threatening to begin foreclosure proceedings, right?
Yes.
Generally, to avoid foreclosure proceedings, one of the ways to avoid foreclosure proceedings is to pay off the debt, right?
I would assume so, yes.
So, in your discussions with Mr. Weems before signed any kind of contract stating that the notes were being purchased, did he tell you he would not accept the balance of the notes with principal and interest in satisfaction of the notes?
Sorry, can you repeat that?
Did Danny Weems tell you, strike that, At the time you purchased, or the L&L Line Services LLC executed this contract to purchase the secured lien position of the bank, the outstanding balance was $486,000 and a few $100s on top of that, right?
Generally correct.
Okay. Did Mr. Weems tell you that if you paid $486,000 and whatever that additional amount was, that that would not be acceptable?
I don't recall that.
Did Mr. Weems demand that you pay an additional $50,000 in order to avoid foreclosure on those notes?
He did not demand I pay $50,000 to avoid foreclosure on the notes.
You could have avoided foreclosure on the notes by paying the $486,000 and change that was outstanding at that time, right?
Your Honor, that calls for him to speculate in terms of whether he would have avoided foreclosure. The foreclosure decision was the bank's decision, not Mr. Thayer's.
I'm gonna
Repeat the question, please.
You could have, the foreclosure could have been avoided by paying the $486,000 and some odd dollars that was outstanding on the notes, right?
Again, that would be a question for the bank.
So are you trying to tell the court that if you walked in with a check for $487,000, that the bank would have gone forward with foreclosure?
Again, I don't know if they would or not. The debt from the notes was generally $498,000. I believe there was also an overdraft that was at issue as well, best of my recollection.
Objection, non-responsive. Well, certainly Mr. Weems, the bank president, didn't tell you. The only way to avoid any foreclosure is for you to purchase the notes, right?
I don't recall him saying that.
At the time of the on April 20th, 2020, you knew that the notes owed by J&L Utility Service Company to Wood County National Bank were in default, right?
Yes.
And at any time before you executed any kind of contract to purchase the bank's secured position, was that default ever cured?
I'm sorry, can you repeat that?
The default that you knew existed on April 20th, 2020, that default had not been, let's put it this way, was it cured at any point after April 20th, 2020?
I'm sorry, I couldn't hear you.
Was the default on the notes owed by J&L Utility Service Company to Wood County National Bank that you knew existed on April 20th, 2020, was that default cured at any point after April 20th, 2020?
I guess I would assume so, yes.
And what was it that cured the default?
The purchase of the notes.
Do you recall a meeting involving you, Mr. McConaughey, Sarah Boyd, Nancy Boyd, and Ronnie Boyd in Van, Texas in June 2020?
Yes.
Does the date June 1st sound correct to you?
Yes.
I believe you're contending that the purchase of the notes from the bank occurred after this June 1st meeting, right?
Again, I'd have to look at the dates,
You mean the dates on the contract,
the dates on the purchase of the notes.
the contract to purchase the notes?
Descriptions right here. Legal description attached here. Exhibit C, which one is that? This is the transfer. That's the transfer.
Your Honor, may I approach the court reporter?
May.
As I mentioned before, we pre-marked our exhibits as avoid confusion. I'm just picking up with the numbering that we had in our pre-marked exhibits. So this is actually, although we don't have 50 exhibits yet, I'm marking this as plaintiff's exhibit 50. I believe the same as what was going to be at the first hearing on this case. Defendant's Exhibit. Well, loan purchase agreement.
The loan sale agreement?
Excuse me, loan sale agreement.
See, yours just for sure. Pages. It's actually two documents. That's the transfer.
All right.
One's going to be this exhibit 1. The second one's going to be 50. The second one's going to be exhibit 51.
51 or 50-1?
No, 50 and 51.
So just to be sure, correct, 50 is the loan sale agreement. 51 is the transfer of note and lien document.
Okay. Hand those to Mr. Thayer. Our exhibits 50 and 51. The documentation of what we've been discussing, the purchase of the secured lien position from Wood County National Bank.
Yes.
And the loan sale agreement, go to page 9. That's the signatures. See that?
Yes.
All right. And is that your signature there under L&L Line Services LLC?
Yes.
You see the date says June 4th, 2020.
Yes.
Did you in fact sign this document on June 4th, 2020?
Yes.
And is that the signature of Danny Weems across from your signature on page 9 of the loan sale agreement?
Yes.
Were you present when Mr. Weems signed this document?
I don't recall that.
All right, Mr. Sanders, we're going to go ahead and take our lunch recess.
Oh, I apologize, Your Honor. Okay.
Lost track. Are you offering those at this time?
Yes, I'm sorry. I'll go ahead and offer 50 and 51.
No objection, Your Honor.
All right, court will admit plaintiff's exhibits 50 and 51 into evidence. Court will stand in recess until 1:30 for lunch. I would ask counsel before we resume at 1:30 to work together if there could be any agreements on the pre-admission of any exhibit that may speed things up for us this afternoon. And just remind you that we're scheduled until 5.
Yes. Yes, Your Honor.
For time accordingly. You may sit down. Yes, sir, just take it right. You may sit down. Thank you.
You have your exhibits. I can look at those to see if there's anything I can stipulate.
Yes. Oh. Chester. So, well, you're, I don't know if it was right. Sorry, hang on. Client, I guess.
Yes,
But in the agency situation, we do it else.
now you're thinking of the Senate one. You're thinking 10. If you've got a more complete copy, if you've got something. I think there was email, letter. That was it.
ready to proceed?
I believe so, Your Honor. We're actually trying to work out some of the admissibility issues.
Go ahead. Keep working. Also, before we go on the record, I failed to mention that we're streaming to YouTube today. So, we mentioned to the young lady who's sequestered, but just so that you're aware of that, we are streaming on YouTube.
We've already made her aware that that may be a possibility, not to look it up. That's really search out.
But halfway through that,
So are they requiring everything be streamed? I mean, because I don't think y'all have blocked off and said the court, the public can't come in. You're just doing it anyway.
I'm doing it anyway, and I'm using this test, so for the Zoom trial, I do the motion hearing versus like bench trial or something like that. Wait for it.
Or a felony jury trial, you'd like to have it dealt with beforehand. I could see that, Judge.
I've got two other
All right, we are back on the record in cause number 20-130, J&L versus L&L. And the court is ready for the stipulation with regards to with regards to the plaintiff's exhibits and also the defendant's exhibits.
Yes, sir.
Who's going to announce those?
Mr. Sanders, you want to offer yours?
Sure. I believe that defendants do not have an objection to plaintiff's exhibits 5, 6, 26 through 29, 31, 32, 33, 30, and 34. I think those are the only ones that they've agreed to.
And 46 through 49, sir.
Oh, sorry, yes, 46 through 49. So, so those exhibits, plaintiff will offer those exhibits.
All right. Then the court admits plaintiff's exhibits 5 and 6, 26, 27, 28, 29, 31, 32, 33, 34, and exhibits 46, 47, 48, and 49. Is there an agreement on any defense exhibits?
Yes, Your Honor. Some of them are redundant. I'm going to go ahead and offer, but as a practical matter, some of them already been admitted on plaintiff's side.
Okay.
So those would be exhibit for defense. Exhibit 1, it's not previously been stipulated. Exhibit 2, which is also plaintiff's exhibit 1. Exhibit 3, which is plaintiff's exhibit 2. Exhibit 4, which is plaintiff's exhibit 4. Exhibit 10 and 11, which are subsets of 49. Exhibits 12 and 13, which are defendant's exhibits. Excuse me, plaintiff's exhibits 33 and 34. Exhibits 15 through 27.
14 also, counsel.
Oh, I'm sorry, and exhibit 14. Exhibits 29 through 31. And 38 and 39.
Did you get 23 through 27? Did I miss that? Oh, 14 through 27. I thought you said 22. Then that's correct.
Okay. Then the court admits by stipulation defendant exhibits 1, 2, 3, 4, 10, 11, 12, 13, 14, 15 through 27, 29 through 31, 38, 39.
Right. Your Honor, I do want to make one notation on this point, and that is Exhibit 13 is we're back to it's a redacted bank statement. I have the redacted bank statement because that's all I have. I mean, they obviously wanted to offer it as evidence also. I still don't understand how we can have redacted, non-privileged documents being introduced into evidence. And that's the one where there's redactions and pages 8, 9, and 10 are missing.
We'll take that up later.
So, I mean, to the extent it's the same as what I have, there's not an objection but the objection I have is, again, that they have the unredacted complete version and we don't.
Anything further?
I'll raise a practical point, Your Honor. I mean, now that I've gotten some exhibits that we've got pre-admitted and I've gotten some basic stuff down, I can move a lot faster with Mr. Thayer. I don't see how we're going to get through. Even if I will call Ms. Boyd today. I don't think we're going to be getting to any other witnesses today. The thought I had was because so much of the evidence ends up being duplicative, is we go to 5 today. Right now, you have us down for 1:30 on Thursday. And I think I originally asked that that be afternoon, not morning, because I wouldn't be able to come up the night before. I can now do that. So if the court still has Thursday morning open,
And I don't believe we do.
you don't?
I
Okay.
believe we were booked on Thursday. I looked at that saying it was my impression, the same was your impression, that we may run out of time today. We'll address that in a moment. But I went and I looked at Thursday, 29th, and we have settings at 9, 10, and 11.
Right. I think you reserved the afternoon for us.
Correct.
So it'd still be the same suggestion, which is we go ahead and fold it because, like I said, I anticipate we could get through with Mr. Thayer and Nancy Boyd today. I don't see how we would get through 3, possibly 5 other witnesses this afternoon between now and 5 o'clock.
I'm not sure that that's my issue.
I understand. I mean, I'll call Ms. Boyd, Nancy Boyd. I'm just saying that I don't think after that's done, there will be time for any more witnesses.
I know. What I'm wondering is, can you make your case before 5 o'clock?
Yes,
You can meet your burden before 5 o'clock.
I can make,
With Mr. Leister getting a chance at cross-examination.
yes. I think I can meet my burden with Mr. Thayer and Nancy Boyd.
Okay, so if that occurs, then the court would entertain us continuing over to Thursday afternoon.
If that's what they want to do.
All right. You ready to begin?
Can I say one other thing? As a practical matter, I do not believe we would get to Sarah Boyd Gary today. And she's had to go get a job after all this happened, and she's supposed to start work at 4 o'clock today. If we can go ahead and release her, keep her under the rule, but go ahead and release her because I don't think we're going to get to her today.
Mr. Leister?
I don't have any objection.
Okay. Ms. Boyd, or Ms. Gary, I'm sorry.
Hang on, you're on. Let me consult.